Good evening. Welcome to the City of Tempe's Board of Adjustment meeting for Wednesday, October 25th, 2017. The Board of Adjustment is authorized by the Arizona Revised Statute and the City of Tempe zoning ordinance. Its function is to grant relief where a literal enforcement of the zoning ordinance would result in an unnecessary property hardship, to interpret provisions of the zoning ordinance, and to hear appeals from any person or city official aggrieved by the decision of a person responsible for the enforcement of the zoning ordinance. The board has the City of Tempe Community Development staff summary reports on the item being considered at this meeting and will use the report in their deliberations. All applicants and interested citizens, when your request is called or when you wish to address the board, please make sure you have filled out one of the citizens request forms located on the table in the back of the room. Then step up to the microphone and state your name and city of residence. Please submit the white form to a staff member before you begin speaking into the microphone. I'd like to first introduce our staff members, City of Tempe. On the end is Steve Abrahamson, and then in the middle is Ryan LeVake, and to his left is Diane McGuire. My name is Jan Sell. I'm chairman of the board, and I think what we'll do now is do a roll call. So David Lyon. Here. James Frazee.
Here.
John Pazalkis.
Here.
David Noggle.
Here.
Richard Casal.
Here.
And Kevin Collins.
Here.
First order of business would be to approve the minutes of the September 27th, 2017 meeting minutes. I think the minutes have been presented in the packet. Is there any discussion, corrections of the minutes? Then I'll entertain a motion to approve the minutes of the meeting.
Mr. Chair, I move that we approve the meeting minutes for the meeting dated September 27th, 2017.
Second.
Who was the second? Okay. It was moved by Mr. Lyon and seconded by Mr. Frazee that the minutes be approved as written. All those in favor say aye.
Aye. Aye.
Aye.
And I will abstain because I was not at the meeting. The first case tonight, and the only case tonight, is a request and appeal of the zoning administrator's decision to deny the proposed medical marijuana dispensary located at 8611 South Priest Drive, Suite 102, Unit 104, for Park Dispensary, case PL 170260. The appellant is Sachs Tierney, PA. Is there someone from Sachs Tierney to come forward, state your name and address for the record?
Actually going to be me.
I'm sorry.
Good evening, Chairman Sell, members of the Board of Adjustment. The case before you tonight is a request to appeal the hearings, I'm sorry, got me going on this. The zoning administrator's opinion of August 30th, 2017. This request was for an administrative review of the proposed medical marijuana facility at 8611 South Priest Drive. It's in the PCC1 zoning district. Essentially, it's located at the northeast corner of Warner Road and Priest Drive. The applicant, the application was made on August 14th of 2017, and the letter of denial of the request was made, the decision was made on August 30th. I take that back. The decision, yes, the I have this backwards. The decision was made, the determination was made on August 30th, and it was applied for on the 14th of August. Subsequently, within 2 weeks, we received the request for an appeal of the decision. The request, or the decision was based upon 3 items. Firstly, there was a dispensary that was approved previously at this location. Must state that this was under different separation requirements at the time. Subsequent to that decision, there was change to the separation requirements. One change was there's a 1,500-foot minimum separation between a dispensary and a child care facility. There is a child care facility located north of this location at the northwest corner of Ruby Drive and Priest at the Lifetime Fitness facility. The exact distance of that is, and we do have a map. Oh, beg pardon, I left my map right there. Oh, the map, pardon my, okay. Put it together here. Thank you, Mr. Levay. The location of the proposed dispensary is the northeast corner of Priest Drive and Warner Road. The Lifetime Fitness, where the child care facility is located 1,430 feet property line to property line to the north-northwest. Lifetime Fitness at Ruby Drive and Priest. Again, property line here to here. The second separation requirement that is the distance from the property line of the dispensary to residential zoning. There's the land use is residential zoning. And due to the land use being within 900, is it 1,200 feet? It is 1,200 feet. The land use for residential use, bear with me here a moment, is 1,320 feet, thank you, and the residential use is within 890 feet. So again, there are 3 rationale for the decision that was made by the zoning administrator. I can take any questions you might have. I'm sure I muddled this up enough that you might have a question.
I have a question. When you're measuring from the property, you're measuring, it's an individual condominium unit within that project, correct? Or is it a suite?
It's actually from the zoning line, the north parcel.
Yeah, if I could clarify, so the readings in the code measure from parcel line to parcel line. So because that's a condominium unit, you actually get a more finite measurement of that condo unit parcel from the affected property that contains the separation use requirement. So I'll read the language in the code. It specifically says a medical marijuana dispensary shall not be operated or maintained on a parcel measured by a straight line in all directions without regard to intervening structures or objects from the nearest point of the property line of a parcel containing the following, which includes the items that we have described.
Thank you.
Mr. Noggle?
Yes, Steve, you mentioned there had been a previous application that had been approved under different requirements. The nature of that approval, is there a certain amount of time that the applicant needs to perfect what he has applied for?
Yes, that approval was a conditional use approval. That request went through the review process. They were given basically 60 days to either submit for building permits or provide evidence that the state process was applied or active at the time during that 60-day review period. Subsequently, following the applicant for the natural herbal remedies application that use acceptance that was approved, went through a building permit review to get a permit, and they've actually received a C of O as a result of that process.
Other questions? Mr. Frazier?
Is this within the same complex or within the same unit?
It's the exact same unit.
So for clarification then on my part with that, the natural herbal was approved, and then the unit was constructed for them?
Correct, yes, and I think it was a very simplistic TI permit. It was just some tables and chairs to allow office use in that area. There wasn't any significant structural improvements that we could recognize, but other than that, the CVO was issued for office use.
Isn't, again, for clarification either for you or for the applicant, then isn't part of the appellant's comment that they've spent money to improve the space based on what was previously approved for natural herbal, not for park? Is that correct?
That's correct. That would be correct.
So why do we have an issue here?
We have an issue because we have an application that was applied for after the new ordinance went into effect that had extended the separation requirements. And under that new ordinance that was approved and adopted on May 25th and in effect on June 25th, this application was submitted in after that date. We reviewed it under the current ordinance and it did not meet the separation requirements required for that land use. The previous application did at that time.
If the law was changed or any other ordinance inside the city of Tempe that would not allow for residential construction on the remaining property near the San Simon property, would San Simon have to scrape their business? And is there a such thing as vested property rights?
No, in this case, the residential land use referring to is an allowed use within that zoning district. So you know, what you're describing is whether or not there was a legal nonconformity use occurring at the time. And when the initial application was made, there's specific language and condition criteria that it's for that business and purpose only. So it's identified in the specific limitations of the original use acceptance letter. And I think that letter is provided in your packet.
Could Natural Harbor assign their interest in the approval, in the permit?
If it's still natural herbal remedies, they would be allowed to operate there under our use acceptance allowance.
So they have to operate under the same name, is that what you're saying? Thank you.
Entity.
I recognize Mr. Lyon.
Thank you, Mr. Chair. So I just would like to clarify a couple things then. The use acceptance is, would you say that it is an entitlement attached to the property?
The use acceptance is specific to the business or applicant that filed the application and the subject site that they requested the location. It is required that the property owner sign acknowledge authorization to proceed with that application request. We certainly recognize that there has been some ownership changes in this condominium unit at the time when it was processed under a different ownership name. The business and conditional approval was specifically identified for the applicant that applied for that use acceptance as well as the business identified for the request.
So in other words, by purchasing that property, you do not necessarily receive that use acceptance yourself. You must be the same entity that applied for the original
Correct.
use
Otherwise, a new application must be received by the city. So in other words, what we don't want to do is we don't want to have multiple approvals of different uses, different businesses on the same site.
Again, for my clarification too, so when this application from Park was submitted, I mean, the applicant knew that there was a new requirement. Is that right, or was the applicant under the impression that because this property was approved under a different?
I could not say that, so you'd have to ask the applicant that question.
Okay.
I've got one more question regarding that transfer of ownership. And there's a lot of material here, and I have gone through it all, and I noticed that it was inspected within a month of changing ownership. Did the ownership change after that inspection and the issuing of the certificate of occupancy or before?
I'm not clear on the ownership change. So
Well,
maybe
the ownership change is the issue here, isn't it?
I was, in my interpretation of the packet, and I made some notes, the ownership changed on August 16th, 2016. The C of O was given on November 3rd, 2016. So this ownership changed before the C of O was given.
And that's the nature of my question. Is that accurate? So the certificate of occupancy was issued while the Park dispensary was.
that may be the case, yes, but the use acceptance is not for the ownership of the property, it's for the business.
May be the case or is the case?
Is the case.
Thank you.
Mr. Lyon?
Chairman Sell, thank you. One more question, if I could. Well, maybe it's two. The property at 9010 South Priest, can you tell us what its current zoning is? The appellant has listed it as MU3.
Yes, that's correct. The property is listed as MU3 and as a sole source as a residential land use. The separation requirement was measured based on the use of the property, not the zoning district designation. So in this case, that property, multifamily, it's a Mark Taylor apartment complex, which triggered the separation requirements measurement from parcel line to parcel line.
So you're saying the uses on that property are entirely residential, therefore they meet the criteria for solely devoted to residential use?
That's correct. So in a situation, if you had like vertical mixed use, where you had commercial also on the property, we would not consider the property to be within requirements for the separation land use.
Thank you, Mr. Levesque.
But that's confusing to me also, because this is MU3 mixed use, which allows commercial. Is the zoning at, say, the Circle K there on the very corner, or at the nightclub, is that MU3 also?
No, it's not. That's PCC zoning. But there are provisions that it would allow residential with a use permit as an ancillary use. If that property was devoted to a residential land use, maybe not legal nonconforming, then we would consider the separation requirement. I'll read the language in the code that basically states that medical marijuana dispensary shall not be operated or maintained within 1,320 feet from a residential zoning district or the property line of a parcel solely devoted to a residential use in any zoning district. So it's the act of the use that's on the property today.
But that's with the most recent zoning changes regarding this whole issue, not while the certificate of occupancy was issued.
That provision was still in place at the previous time, but there was a different measurement. Previously, it was a 500-foot separation measurement. Now it's 1,320 feet.
So it passed under the previous rules, and now it does not.
Correct.
Okay.
Any other questions for the staff? If not, may the applicant approach the podium and state your name and city of residence.
Push a button. Oh, okay. Philip Rudd and Janet Jackham of Sachs Tierney on behalf of the applicant Image Productions, LLC. Mr. John Batistas, the principal of Image, is in our audience also. I may be calling on Ms. Jackham to assist me with some of the facts. She's much more familiar with some of the underlying facts and background facts than I am, so she may assist me with some of those questions that you may have.
That's fine.
We are here to request that the board overturn the city's denial of our use acceptance letter to open the medical marijuana dispensary at that location. As a side note, this isn't mentioned in our papers, and I'm not sure how much influence it will have, but as a side note, Mr. Batistas wanted us to emphasize that he has entered into an agreement with the condo association, the Warner Village, that this dispensary will not sell recreational marijuana if and when that is ever passed by the state. This will solely be a medical marijuana facility pursuant to the agreement between Mr. Batistas and Warner Village. As was mentioned, the city's denial is based on three things. First, that the proposed dispensary is too close to a, quote, child care facility. Second, that it's too close to a, quote, parcel solely devoted to a residential use. And third, that there already exists a use acceptance letter with respect to this property that has not expired. We submit that all three of those grounds for the denial of the use acceptance letter are wrong and improper, and we request that you overturn the denial. I heard the discussion just now with the folks from the city. I want to start, though, with the child care center restriction. I want to emphasize that this child care facility that is causing this issue it's not a tutor time, it's not a La Petite Academy, it's a room. It's a room inside a Lifetime Fitness Center where people that go to exercise drop their kids off there for no more than 2 hours at a time. Parents have to stay on the property with their kids while they're working out in the facility. And it's tucked away in the back of the facility, away from the entrance. Okay. So that's what we need to picture when we're talking about this child care facility and whether this proposed dispensary is too close. It's not a La Petite Academy, it's a room inside of another building. Okay. Now, even if this room were considered to be a child care facility, and I'm going to get to that in a minute, but we don't believe that it is for a bunch of reasons. But even if it were considered to be that, we submit that it's not within the 1,500-foot restriction. Now, I heard the city tell you that, and put a map up here that that says that it's, I believe it was 1430, but we don't know how that was measured. We submitted with our materials a Google Map developer picture that shows that the distance between the Lifetime facility, the Lifetime Fitness Center, and the proposed dispensary is 1,933 feet, which is well in excess of the 1,500-foot restriction. We also put a picture in with our papers that showed that, according to a different view, an aerial view from Google Maps developers, that it's 1,534 feet, again, in excess of the 1,500-foot restriction. I don't know how this was measured by the city, and honestly, technically, I don't know how Google Maps does it either, but at a minimum, it appears that this is definitely beyond the 1,500-foot restriction. So even if this were to be considered a child care facility, it's not within the restriction, and therefore the use acceptance letter should not have been denied on that basis. So let's talk about whether it is a child care facility. Because if it's not a child care facility, this use restriction doesn't apply, whether it's 1,500 feet or 500 feet. There's nothing in the zoning code that defines child care facility. So we got to look to state law. State law has some definitions of both child care and child care facility. It's in Arizona Revised Statute section 36-881, 2 and 3. 2 defines child care, 3 defines child care facility. I want to read you those definitions. Child care means the care, supervision, and guidance of a child or children, here's the important part, unaccompanied by a parent, guardian, or custodian, here's another important part, on a regular basis for periods of less than 24 hours per day in a place other than the child's or the children's own home or homes. That's what child care is defined as. Child care facility is defined as a facility in which a child is regularly provided for compensation, where child care is regularly provided for compensation for 5 or more children not related to the proprietor. So let's take that one step at a time. Here, what we're dealing with is the room at a Lifetime Fitness where parents drop their kids off while they go exercise. We provided in our materials the Lifetime Fitness policy that specifically provides that a parent must remain in the Lifetime Center at all times while the child is in the Child Center. This is not a situation where the child is unaccompanied by a parent. He's right there in that building. So, that doesn't fall within the definition of child care, because remember the statute says that it has to be unaccompanied by a parent, guardian, or custodian. We interviewed, we had one of our consultants interview Helen Ungangst, and I'm sure I'm butchering her name, so I apologize to her. She is the child care licensing supervisor at the Arizona Department of Health Services. And she informed our client's consultant that the state does not regulate facilities where parents are not on site. Or I'm sorry, where parents are on site. So here we have a situation where the parents are on site. This alone removes it from the definition of a child care facility, removes this Lifetime Fitness building from this use restriction. But there's more. The statute also says that the child care facility has to regularly provide child care in order for it to be a, quote, child care facility. Here we submit that the timing of and the restrictions on children's use of the child care room in this building is such that this does not make it regularly providing child care services. In fact, we attached in our papers an article. It was an article about some parents that were disturbed by the fact that their 8-month-old child, who was being cared for in an LA Fitness child care center, wandered off and was found wandering around in the gymnasium. And in the article, a lady named Kara Christ, who is with the Bureau of Child Care for the Arizona Department of Health Services, stated that this isn't a situation that they regulate because they don't watch kids on a regular and routine basis. LA Fitness is basically the same thing as a Lifetime Fitness. The child care situation, basically the same thing. Here, We've got the child care center where the parent can only leave the kid for 2 hours at a time. It's only open during certain periods of time, not 24 hours like the facility itself is open. So we submit that this room in Lifetime Fitness is not a facility that regularly provides child care. The third thing is, and we've pointed this out in our papers as well, if you compare how this Lifetime Fitness facility is taxed and how it's recorded on the county assessor's books versus how, for example, a La Petite Academy or a tutor time is taxed and identified. This Lifetime facility is not taxed or identified as a child care facility. It's not. It just simply is not. So, the first ground for denying the use acceptance letter should be rejected. This is not a child care facility, and even if it were, it's not within the parameters, the distance parameters. Second point, the second reason for the denial is that this proposed dispensary is too close to a residential use. Now, I'm going to take a little bit of an exception here because when the city was talking to you, they glossed over a little bit what that residential use restriction is. It doesn't say residential use. The zoning says, again, got to read it carefully. You can't just gloss over it. A parcel solely devoted to a residential use. Solely devoted. We can't have the dispensary within 1,320 feet of a parcel that is solely devoted to a residential use. Here, the city says that we're too close to the San Sonoma apartments. But again, just like with the Lifetime facility, the Lifetime Fitness facility, we did a Google Map search. I don't know how they did theirs, but we did a Google Map search. Our Google Map search showed that we are 1,753.33 feet away from the San Sonoma apartments. GPS Visualizer, which is some other computer-based mapping system that we use, says it's 3,745 feet away. I'm not sure I buy that one, but the point is that our search showed that we are not within the 1,320 feet. That is the limitation. So, even if this parcel is residential property devoted solely to residential use, it's not within the distance restrictions. But perhaps more importantly, and one of you, I apologize, I don't remember which one of you, raised this also, which is this property that we're talking about, where the San Sonoma apartments are, it is zoned MU3, mixed use. It's been that way for years, since 2012. The intention of this zoning was for commercial and residential use. It's not a residential district under the City of Tempe's zoning code. Rather, it provides for and allows for proposed commercial development. Now, the San Sonoma apartments might be the only thing that's there right now, but a week from now, somebody else might build something there. Zoned for it. It's zoned for it. And if that, remember what we're talking about, not just residential use, solely devoted to residential use. Okay? So if somebody builds another commercial property there, as they're allowed to under the current zoning, does that eliminate this restriction? I think it does. Why do we have to wait? We shouldn't have to wait. It's zoned MU3. This parcel is not devoted solely to residential use. Moreover, as a matter of fact, there is substantial commercial properties surrounding this particular parcel. That buffer the distance between the proposed dispensary and the apartments. So we submit that this property does not violate that particular restriction, and the city's denial of the use application or the use letter is improper. I want to talk a little bit of policy also, I think. And we addressed this in our pleadings, and that is this. I don't know if this solely devoted is more restrictive or less restrictive than just simply devoted to, which the devoted to language is used in adult-oriented businesses, use restrictions for adult-oriented businesses. Can't be within a certain number of feet to a parcel that is devoted to residential use. They don't use the term solely devoted to. I don't know why. But the zoning restrictions with respect to adult-oriented properties or businesses, there's a lengthy discussion about the special purpose for those regulations that talks about concerns that the city has with adult-oriented businesses. So you would expect that the regulations of an adult-oriented business would be strict. Here, though, with respect to medical marijuana dispensaries, there is not a lengthy discussion about the special purpose for any of the regulations. There is no expressed concern by the city over a medical marijuana dispensary. So you would expect that this restriction would not be quite as strict. If it's interpreted to be stricter, it's our position that such an interpretation and such an application would be unreasonable and in violation of state law. Finally, let's talk about the existing use acceptance letter. I want to make sure that we're clear on the facts, and the facts are that my client, Image Productions, purchased this property, put a lot of money into this property to develop it, and then got their certificate of occupancy. Okay? The certificate of occupancy was issued under our watch. Okay? So I want to make sure that that's understood and clear. The city asserts that the existence of this 2015 use acceptance letter issued to Natural Herbal Remedies precludes the issuance of another use acceptance letter to my client. There's two parts to that, I think. The first part is, it's our position that we should be grandfathered into that 2015 use acceptance letter because it is a vested right. It is something that we relied on in acquiring this property, developing this property, getting the C of O on this property. So those rights that exist under the 2015 use acceptance letter belong to us. as vested rights. But if they don't, it certainly should not be a basis for denying our use acceptance letter. Particularly when they say, well, it can't be transferred from natural herbal remedies. If that's the case, then why is it impacting us? It shouldn't. It shouldn't impact us at all if that's the city's position. So, all three of the bases for the denial of the use acceptance letter to my client are faulty. They don't exist. So, what we're asking for the board to do is to overturn the city's denial of that use acceptance letter and instruct the city to issue the requested letter for the property located at 8611 South Priest Drive in Tempe. I'm happy to answer any questions to the best of my ability.
Anyone have any questions? Yes, Mr. Fraser.
Thank you for your presentation. I guess a couple questions in regards to the appellant's position that the previous denial was at fault. And with some of the comments that were just made, I can understand the child facility in Lifetime Fitness not being a child care facility. It's, like you said, it's parents have to be there. It's not really a child care facility. But if it were, as you referenced, a La Petite Academy, that would be a child care facility. But you're measuring, it seems like there's some contradictory where you're saying the building for Lifetime Fitness is set so far back that it's outside, the building itself is outside the required measurements.
That's what our Google Maps analysis showed, yes.
For the building itself.
For the building itself.
But if it were a La Petite Academy, those measurements still go to the property line, and because of the driveways, the landscaping, and so forth, that building would still be set back, but that would still be a child care facility within the measurements.
No, it wouldn't be within the measurements, according to our analysis. According to our analysis, we're outside of that 1,500 feet.
The property line or to the building?
You know, that, to be honest with you, I don't know how Google Maps analyzes that. So from a technical aspect, I don't know how Google Maps analyzes that. But I'm glad you asked that question because there is one other thing that I wanted to mention about the child care facility. Let's say that the city is correct, that property line to property line. If the only thing that's a child care facility is that little room, do we not measure to that room? I don't really answer that question either, but I suspect that measuring to that room would put us beyond the 1,500 feet as well.
Okay. Well, and I understand, and I guess I accept that argument for that not being, quote, the ordinance for the child care facility might be inaccurate. But a couple other comments, if I may. When I read through the process is you obtain a use acceptance letter, then you file your application with the Arizona Department of Health Services, then you obtain your building permits. It seems that although National Herbal Remedies had the acceptance letter, you're saying your client assumed that they could just use that and move forward.
I don't know if I'm necessarily saying that. What I'm saying is that if we had just assumed that, we wouldn't have filed this application for this one, right? I think it's a belt and suspenders type of analysis that we knew of the existence of that 2015 use acceptance letter. We didn't know that we weren't certain that 2015 use acceptance letter was still valid and that we could use it. Certainly our position, that's the case, but we don't know if the city of Tempe would agree with us on that. So we did our work, and then we came in and we asked for this current use acceptance letter.
Okay. And then I guess with the last one, it's the apartment complex is a single-use facility for residential, correct?
As far as I know, sure.
Okay, thank you.
Thank you. Any other questions?
Since measurements seems to be one of the big issues here, Mr. LeVay, could you describe how the city does their measurements?
Yes, Chair Sell, basically is what we had already reiterated in the beginning of our presentation, what was ignored by the appellant, is basically that the measurement is taken from the nearest adjoining parcel line, from the subject parcel line of the use that requires the separation. So it's the nearest points. And so that measurement was done by a measurement tool. And if there is a discrepancy where we're like within 5 feet or 10 feet of a potential measurement conflict, then we'll get an exact survey done of that. But we were well within the separation requirements. And I think the Google Maps that were shown and provided as part of the appellant's analysis kind of shows just basically an aerial midpoint map, a star on the map that says Google has identified the residential land use here. And typically when you search for Google, they'll give you the center point of a property or parcel along the frontage of the property, but that's not how the measurement is identified in the zoning code language. It's measured from the nearest adjoining parcel line to the other nearest adjoining parcel line. And that measurement is done, and we provided those measurements for you. I do want to get into and clarifying to the land use of the child care facility. We do have a definition within our zoning development code for a child care center. It's a little bit different, but we've used those definitions interchangeably, either facility or center. And that definition basically identifies that, I'll read it to you. Child care centers means any use regulated by the state of Arizona involving the care of other people's children during the day and that accommodate more than 4 children for child care. Some instruction may be offered in connection with such care. The use shall not be considered a school within the meaning of this code. See also nursery and daycare school. So a little bit of history for you on that one. Back in 2011, when we initially adopted our medical marijuana ordinance, we had about 50 applications, 50 applications that came in. And some of those site applications that came in applied over the Emerald Center area, and we basically cleared about 13 medical marijuana use acceptance requests during that time period. Now, we were the kind of the first step at that time, and then applicants then applied for the state, sort of a narrowing the competition, so to speak, when they applied to the state, and then ultimately one to the north, one to the south was elected to CHA. Well, during that time period when we cleared 13 sites, one of them being within the Emerald Center area, we had been approached by a business representative, a resident that frequents the Lifetime Fitness, and kind of disputed our clearance review of that requirement and request. And part of his arguments saying is that, hey, we've got a child care facility within the Lifetime Fitness. And what we told him and informed him is, when we did the review, we looked and verified from the state their list of registered child care centers. And they were not listed at that time during that review of that process. So the member of the fitness facility took it upon himself to, afterwards, meet with Lifetime Fitness, evaluate the review and their procedures. And what he told us is on certain times, they do have, I guess, off-night facilities where, like on a Friday night, the parents are allowed to leave over a certain time period and leave their kids there under child care supervision. And so they had actually afterwards received a child care registered license with the state of Arizona. And so when we reviewed the analysis for this request, we then looked to the state list of registered child care centers, and Lifetime Fitness was listed under one of those address sites. And that was our determination for the separation requirement.
Could you speak a little bit more about the residential land use, that it's
Yeah,
both residential and the ability to build commercial?
certainly. The property at the time when it was processed for MU3, there was a proposal to do a two-phase project approach. The first phase identified as the San Sonoma Apartments, and the master plan proposal was basically a horizontal mixed use, so not an integrated mixed use. The parcel in question that was designated the commercial land use was a parcel directly south of the San Sonoma Apartments. So they proceeded with their application permit procedures to get the San Sonoma Apartments, and there was never a process or procedure that moved forward with the commercial component of the parcel site. So it was a separate subject site and sort of a horizontal mixed use rather than what you might find in a vertical mixed use environment where you have both commercial and residential on the same lot. There were two parcels that were processed simultaneously, but were in different phases of the request. So the land in question of the parcel that has the multifamily apartment residential land use is fully built out and has full permits for the property site.
I have a further question on the, you read the regulation on the child care facility. You said the city code defines it as a facility regulated by the state. So are you telling us then that that child care facility in Light by Fitness, you've since discovered it's regulated by the state?
That's correct. There's an
That
active
differs
license.
from the evidence in the pack, or the evidence provided by the appellant as a letter
I
from the
don't
state?
think the applicant made any knowledge that they're currently registered or licensed by the state of Arizona right now.
Thank you.
Thank you, Mr. Collins. Mr. Lyon?
Thank you, Mr. Chairman. I'd like to thank the applicant for their great candor and the way you've spoken to us. It would be easy for you to be a little bit less candid, and I appreciate your sincere approach. I'd like to ask you a question, if I could, about the certificate of certificate of occupancy, which you made reference to. Can you tell us, please, what do you wish for us to infer from that? What's the implication of the certificate of occupancy?
Well, part of what I'd like for you to infer from that is that we do have vested interests, vested rights in what existed when we acquired this property. This property, when we acquired it, had this use acceptance letter. That's something, and again, I apologize, I don't remember who asked the question, but is that something that is an entitlement that runs with the land? It's our opinion that yes, it does, and that entitlement that runs with the land is what assisted us in what prompted us to do what we did with respect to this property, to acquire this property, to develop this property, to obtain a certificate of occupancy. That's what I'd like for you to infer, is that yes, we have vested rights with respect to that use acceptance letter.
Okay, thank you.
So I have a further question now that you've stated that you base it on that you had vested rights. I'm looking at the original letter of approval, December 22nd, 2015. And on item 1, last sentence says, any person or business other than those identified herein must file a new application to determine compliance with zoning regulations. So it doesn't appear that you followed that direction on the original letter. It says within that I would believe that would mean you have no vested rights, that you're being told to reapply if you're not those identified in the letter.
Yeah, and I guess there's a couple ways to look at that. The first way to look at that, I think, is does it require that specific entity or just that specific business? I think my take on it would be it requires that business, which is exactly the same business. Natural Herbal Remedies is doing the same exact business that Park Dispensary is going to be doing. So that requirement, that's the way that I would interpret that. But beyond that, and I know this was a thick packet of material that we gave you, but it's worth reading. Ms. Jackham prepared it, and she did an excellent job on it. Part of what she discusses in here is kind of the equities for having vested rights. And it's more than just a black and white legal analysis. What it is, it's an equitable analysis. And that's what the case that she talks about on pages 20 and 21, that's what the courts talk about when they're talking about vested property rights. It doesn't necessarily have to be black and white, statutory. It's an equitable right that these guys relied upon this, and they should be entitled to rely upon this when they exercised their rights, when they put the dollars in, when they made the effort to get a C of O. So it goes beyond just the bald language of that letter. It goes into the equities of what vested property rights means.
Thank you for that further information.
I've got a question, and I think I direct it to the city. And here's where I struggle with this whole thing, is surrounding the property rights. If there is a dispensary or a Total Wine or an LA Fitness that changes hands, does that affect or cause the new owners to go through recertification and zoning to continue on in that business under different ownership? So if the Lifetime Fitness changes hands and LA Fitness buys that facility, changes the sign on it, are they back to square one, and could they be denied of the right to use that property for its intended purpose?
Board Member Causel, what I'll clarify is the land use is not grandfathered in, and it's not a vested right, specifically because of the statements identified under the use acceptance conditional letter of approval. Now, that rights was granted to Natural Herbal Remedies, and if there becomes or creates ordinances or land uses that make that business non-conforming, they're still allowed that right to be there in that location. We still have a use acceptance letter for that. They received a C of O, and frankly, that Natural Herbal Remedies has never opened up or operated for business at this time. So we still have questions and doubt as to what their status is with the state under that license process. And what we don't want to do is put a situation where we have two authorized licenses that would be allowed by the state in the same location.
If I can address that, how is that possible? How is that possible? We own that property. We own that property. Natural Herbal Remedies no longer owns that property. You cannot have two licensees on top of that property because we own it. So you know, with all respect, I don't buy that argument, and you shouldn't either.
Board members, and I'll also clarify, I guess, that Natural Herbal Remedies never owned the property in question. They were authorized by the original ownership of the property to proceed with the request. They are merely an applicant or a business for that site location, not the property owners themselves.
Is that relevant?
It's relevant because of the land use that was allowed for the business that was allowed to proceed with the state licensing requirement. So Natural Herbal Remedies was actually a transfer license from another location in Holbrook, Arizona, and that applicant was granted that right. I know there's been some legal disputes with the applicant on whose owners' rights are for that business, and if they have a rights to that business, then they should be able to open without this process we have today. They should be able to move forward without seeking relief from another business that could potentially open up in the same location.
Mr. Lyon?
I apologize if I take us further into the weeds. Mr. Levesque, did I hear you say that Natural Herbal, boy, I'm having a hard time speaking tonight, that Natural Herbal Remedies at no point owned this property?
Not to my knowledge, no.
Can you enlighten us as to how they were able to apply for a use acceptance at that location without owning the property?
Yes, they have an applicant that was a land use processor, planner, and they, within their request application, they have to provide a property owner's authorization to proceed with that application. And so the property owner at that time signed the application form. They identified the business that the request would be approved to, and the land use planner processed the application on behalf of the business.
Okay, so it is by no means inconceivable that the person that owns the property will be a different entity than the business that will be using it.
Correct.
Okay, thank you.
Any other questions, comments?
Thank you.
That's,
Carousel,
yes.
I failed to indicate that we do have 2 letters that are in opposition to the appeal. One was generated from the owner of the Emerald Center property where IKEA, Lone Star Steakhouse, Total Wine and More are located. And second, we did receive a letter of opposition to the appeal from the folks at Lifetime Fitness, or not Lifetime Fitness, my apology, Total Wine and More, from their general offices.
Yes.
Mr. Avery, can I make a comment on these letters that were provided to us when we sat down here this evening? Dated October 19th from Total Wine and More. What is the nature of their business?
Nature of their
This
business
is an alcohol distributor. A retail, all you have to be is 21 years old to go in there. You can be a sick alcoholic, and they peddle alcohol, and they're going to complain and expect to have an impact on a decision regarding a state-regulated medical priority in the community? And is this supposed to have some bearing on us?
Chair Board Member Council, we don't go through the letters that we receive and deny some of them based upon the way we might feel about a business.
Well, evidently you do, because you've enacted ordinance in the city discriminating against these people that want to fulfill a demand in the community.
That, okay.
I was going to
Thank
say,
you.
I view it as just a letter from a nearby property owner. And you can get letters pro and con, and they could have a vested interest in whether that goes in or not. I think what the city does is they just present the letters to us and you take them at whatever weight you want. I do have a question, but I'll get to you. Okay. How is it that the building permit was issued and a C of O issued to the non-applicant for this facility?
Board member Sella, the building permit was applied under the application for natural herbal remedies, and that issued license was reviewed under that permit. It was applied by the applicants for the business of that site location, and they're the applicants that received the clearance for that request. Now, the C of O is subject to the parcel itself. The C of O identifies an office use, which is actually not even the correct use for medical marijuana. It's actually a retail establishment that, if it was open, would be retail and not office. But nevertheless, the C of O was issued under the natural herbal remedies.
Thank you. Yes, sir. Would you state your name?
My name is John Batistas with Image Productions. I'm the representing Image as an owner.
Okay.
And I don't do very well with public speaking, so if I sound nervous, please forgive me. I don't do this very often. I wanted to just say a couple of things. I heard that the counsel for the Warner Village Association is here to try to prevent me from using this office or this building as medical marijuana. There is a pending lawsuit, but I want to read to you so you hear it from their own attorney what the agreement was, because I went to meet with the board personally. I sat down and said, tell me what your issues are. Let's see if we can work out an arrangement so that you, as the board members, don't have an issue with a marijuana facility at your in the complex. They didn't want recreational. I didn't want recreational. I have 4 children, 3 are teenagers, and I just don't think it's appropriate, personally. And I told them, I will sign a deed restriction that no one can ever do recreational in this building. And they said, as long as you do that, among a few other things, which I'll read to you, because I want you to hear this. This is from, I think, his law firm, from Travis Law Firm. It says, thank you for your letter dated November 3rd, 2016, on behalf of Image Productions, the owner of Unit 102. The Warner Village Office Condominium Association is in agreement with the terms proposed in your letter, which will allow Image to lease Unit 102 for use as a medical marijuana dispensary. Talked about a few other things that were not material. After, and they wanted this very quickly because recreational was being voted on. And if they lost that, they could lose the ability to fight recreational being allowed in that building. At least that would be much harder for them, in my opinion. So I cut a deal with them. That was the agreement. And then after recreation didn't pass, then they said, well, natural herbal remedies, it was material that they have to occupy the property, when our agreement never said that. And the reason I tell you that is because it was very important to them that it was only medical, which is exactly what I agreed to. So you may hear a different story today. I'm not sure what it is, but I wanted to explain that to you. And I did everything they said, and right now it's up to the judge to decide whether their agreement is enforceable. So I wanted to be upfront with you on that. With all due respect, Mr. Levesque is incorrect. I did spend quite a bit of money. It wasn't just furniture or office relocation. We have copies of the invoices. Not only was it legal, but architectural. We had to meet the conditions of the city of Tempe. Something that happened, they want to, say it doesn't fall in within grandfathered in terms of the distance, but one thing that I had to do, which I personally spoke to Mr. Levesque about, is they changed the rules, and I can't tell you exactly what it was, that you had to have a minimum of 2,500 square feet. If you had, 2,500 square feet, any building would have to have a minimum of 3 entrances or exits, and egress and egress. But they said because you applied before this law that changed, you have to go one door in and out. So they said, sorry, we can't approve your building because you are too big in terms of your space. And we said, but the law changed. And they said, we don't care. You have to make it one door, you can't qualify. Went back to the architect. Architect did it so that we totally redid the construction so that the reception area was much smaller for capacity. And we had to do several other things to modify where the bathroom was, where a waiting room was, where the reception was, and we got approved. It took them 20 days to approve it, but we did that. And I don't think that's right that we can talk about grandfathering when I couldn't use that. I'm sorry if I sound ignorant, but it's very upsetting to me. One thing I would ask you, and I own a real estate company. I've always been in real estate. I have different businesses. But just think about this practically, and maybe it doesn't matter, but you brought up about the alcohol, and I happen to agree with you. What would happen today if Total Wine went out of business? Let's say they lost their lease and the landlord wanted to make it higher. For whatever reason, they went out of business. And then you get another liquor store that wants to come in. They don't lose their rights. Yet for medical marijuana, they're saying, sorry, that doesn't apply to you. if a medical marijuana facility went out of business in 6 months, or the owner got hit by a bus, and they had to sell to a new person to buy it, another medical marijuana dispensary, what do you say? Sorry, there's an apartment building, now we changed the rules, you put all this money into it, and you can't be there anymore? It doesn't seem fair. I don't understand that. One thing I'd like to point out, and I don't think it was pointed out, and I don't believe I'm wrong on this. At the time, the city of Tempe was aware of all the zoning and approvals of the apartment building that they're claiming that is now I'm too close to. At the time, even with that old ordinance or the distance, it was still too close. So they're saying that, just to give you an example, if it was 500 feet, they were within we were within 500 feet away, if I understand how it worked. But they still approved it knowing full well there was going to be an apartment building there. Now it's 1,000 or 1,300 square feet or whatever it is, and it's the same situation, but now they're saying, oh, sorry, we can't do that. Well, they knew that was going to be residential. They're going to say, it's solely, and now we figured it out. I don't know what it is, but that also doesn't seem fair. I think that's all I have. I'm sorry, I know I sound nervous and whatever, but it's really important to me, and I don't think it's right. And I hope that if you have any questions, I'm here to answer them straight up. I won't pull any punches or mislead you in any way.
Thank you. I appreciate your comments. It's my understanding under the Newton law, as far as multifamily or residential uses, wasn't it 500 feet?
At the time the original application was filed for natural urban remedies, the measurement at that time was 500 feet.
And it's my understanding that the city's measurement now is 890 feet. Is that correct?
Well, to correct, the separation requirement for the prior 2015 application, the separation requirement was 500 feet. So the measurement, yes, was still approximately 890 feet. The ordinance adopted by the City Council on May 25th extended that separation requirement to 1,320 feet. And as a result of that, when we received the application after that new ordinance, the subject site is now not in compliance with that separation requirement.
Yeah,
Yes.
oh, I'm sorry, I didn't.
No, go ahead.
Yeah, when I met with Mr. Levesque about a month ago, he said, as long as you get, and he can tell you if I'm wrong, well, you applied after the fact. I said, so if I rescind my application, he said, as long as the state gives you approval to operate there, there's nothing we can say. So I said, well, if we just rescind that application, then, and if the state says, go ahead and you can go in, he said, there's nothing we can do about it. To me, that doesn't make any sense. Why is that a technicality when it was already approved for dispensary? And he said, but you got to get natural herbal remedies to say they're not going to be there. Well, I own the building. There's no way they can be there without how could I have two dispensaries there? It doesn't make any sense. And the state would never allow two dispensaries in the same building. It's just illogical.
Thank you. I understand your point. As far as the letters go, I don't give much credence to the letters. You got to read them, and they're nice, but
Which letter? I'm sorry, which
well,
letter?
the two letters from the nearby property
Oh,
owners.
no, I understand. You got to consider everything.
And as far as the child care facility, I was convinced that it wasn't a child care facility, but after the city did their research into it, and since the state considered it as one, it's a child care facility. However, I have a hard time understanding that. And I think that to me, that wouldn't be, while it's, from the law standpoint, that's what it is, from a practical standpoint, it isn't. As far as the or the residential use within the 890 feet or within the 1,320 feet, I think that still holds true. And as far as the certificate of occupancy and the vested rights, that's probably the hardest one to deal with right now.
And may I ask you this, just being in real estate, what happens if tomorrow, let's say that the apartment building was even closer and it, or farther away, or how you change the rules, or let's just say it is the way it is. Let's say it's strictly for residential. And they decide to add, which is happening now because I'm involved in certain businesses where it's a assisted living or it's an apartment building or it's a condominium, and they add a Starbucks. And they don't have to go for certain zoning. They get to do it, but they're selling to a third party. Does that mean now it's not residential when they don't even have to apply? I mean, it seems arbitrary, where if I wanted to have, if I was a competitor, I'd say I have Harvest, for example, and I could open up a child care facility the next day next to my office and leave it there and have one person there 1 hour a week and say, oh, you can't use this now because this is a child care facility. After the law has changed, after I've spent all my money, after I relied on the city, I did the work after getting the approval for the permit. I got the certificate of occupancy. Why would that change after the fact? It would be like telling Total Wine, sorry, you went out of business, or you got hit by a bus, and now you lost all your rights. You lost your tenant improvements, you lost your business. It doesn't seem fair.
Yeah, I have a question, and I don't know who to even address this question to, but this idea of vested rights, I heard grandfathering. Who makes a determination on if that's right or not? I mean, is it us? Is that a legal determination? Who would determine if there were vested interests in this, or if there was the right to have this grandfathered? I mean, it seems to me, I'm trying to understand this. It seems to me that's a legal issue. Is that not? Am I wrong with that? I mean, wouldn't that be something a court of law would have to address, as opposed to board members or opposed to people, staff members with a community? I guess, yeah. Does anybody have an idea here?
I have a conflict of interest answering that, but, just think about if you own the building, you spent this money based on the permit and the C of O, and then all of a sudden, anything happens. Now you have to give it to another dispensary, but you've lost all your rights. It's supposed to, the state says to be reasonable in the decisions for the city of Tempe. This is not reasonable.
I understand that completely. I'm just, but to make that determination, who makes that?
If I may, you certainly have that ability to make that determination by overturning this decision.
I understand that. I understand it also. But I'm an engineer. I'm not a lawyer. So my question is, I mean, in any kind of a dispute like that, how would that decision be made? Would it be made in a court of law?
It could be made in a court of law, but it also can be made by this board. This board can make that determination that the bases for the denial of this use acceptance letter were wrong, including the existence of that 2015 letter. In fact, I think this board can make the determination, and one of the things we're asking you to do is make the determination that 2015 use acceptance letter applies to this owner, to Park Dispensary. And I think you have that ability to say that and tell the city of Tempe to issue the use of acceptance letter, even based on that old letter.
And I'm not a lawyer, obviously, but I always use the movie as an example. In the movie The Verdict with Paul Newman, he tells the jury, today you are the law. You make the decision. That's why you're here, and I'm hoping it's in my favor, but it's, That's what I have to say.
Part of the problem, again, is that the state has certain rules regarding the issuance of the license. And it was issued to another entity and not you, even though you spent the money under that other entity to finish out the space.
But it can't be the property owner. It has to be the licensed dispensary, but that has nothing to do with the city of Tempe. The state says, you as the landlord, you're not the licensee of the license. So we submit, the only way the state says, yes, it's okay, is if the owner of the property says, okay, I will put a medical marijuana dispensary here. Then we have to apply for a permit at the city. We say, here are our plans, here's the license holder. But why should, so, and maybe let me go a little further. So what is the harm, what is the, if in 6 months, Natural Herbal Remedies went out of business, or a year, or 2 years, and another one came in, what is the harm to the city of Tempe? They already approved that use. It's like if Total Wine went out, they wouldn't have to go reapply, but there's no harm. They already approved that use, and then they change it after the fact. Again, it doesn't seem fair.
Mr. Abrahamson, did you want to say something?
It was just a procedural note. It would be better that before anyone speaks, they get recognized by the chair, Mr. Sellin.
Oh, I'm
Recognize
sorry.
you. No, it's quite okay. Thank you.
I do have a question for you. Did you make any attempt to try to assume their position or contact them that they would sell their business or the license to you?
Why would that matter?
Well, because of this particular issue.
Well, it's great if you want to get extorted. How much do I have to pay?
Right.
And you know what? I paid a lot to get in there. And if
Understand.
it's literally them saying, all right, City of Tempe, clearly they don't want that. We're not going to approve that. But, oh, if I go to them and they say, okay, we'll sell it to you, well, we're fine. I mean, is that really why we're here? I don't think it doesn't make sense to me. But I don't want to be extorted to do that.
Okay.
I'm not saying that I would get extorted, but
Right, I understand.
I've paid a lot of money. But getting here has probably paid more than all of it.
I've got a question for you, sir. And you may or may not know this, but is anybody in your industry or in this thing challenging this ordinance in the city of Tempe as not being reasonable and in compliant with the state directive?
I don't know. I mean, I'm not an attorney, but I will. I mean, if I lose, I lose, but.
Well, one of the points that you brought up in your documentation is that this is probably the last place that could be considered in Tempe. And this is not the first case of this nature before this board either, and it just seems to me that for whatever reasons, the city of Tempe, and I say that widely, I don't know who is adopting these ordinances, they do not want these facilities in the city of Tempe, period. And so this latest attempt was to just outzone it if there's no locations available. The question in my mind is how is that considered reasonable? And that's what they're being directed to do by the state under the state laws and that have been passed by referendum. So, but you don't know whether or not that's being challenged. You're not.
I'm not an attorney. I don't really get into that. But unfortunately, and I would hate to do this because I want to be a good property owner and neighbor, and that's part of the reason why I didn't want to do recreational. But let's just, I mean, I don't want to fight the city. I don't want to do that. So,
Well,
I mean,
maybe sometimes that's
I know
what
but
needs
it's
to
very
happen.
expensive, and you have no idea how much it's, just to get to this point, costs, which I never expected. I thought, again, we could just get another tenant because we've got the certificate of occupancy. The city isn't harmed. That's what I don't get. Any other business wouldn't face this, but medical marijuana. That's not reasonable. I'm sorry if I sound disrespectful. I'm not trying to be.
Any other?
I have a further question.
Okay. Yes, Mr. Collins.
So you've talked about the original letter that was approved under the other business, that you have vested rights in that. Why did you then reapply for a new approval?
Well, that's what they told me I needed to do. And I said, why? It doesn't make any sense. And they said, well, natural herbal remedies. I said, well, they don't occupy the property. And they said, so? I said, they're not going to be there. I own the building. We don't care. So I did. And then they came up with the other excuses. And it was trying to get the permit was like pulling teeth. You talk about being reasonable. They did everything they could to try to prevent me from getting the permit. And nobody could believe it. That alone was expensive. And then I have the association that literally says, if you don't do recreational, we don't care. They never met natural herbal remedies. They never talked to the principals. They didn't see any financials. They knew nothing about it. They only talked to me. And then afterwards, after we have an agreement in writing, they sent another agreement saying, oh, if you sell the property to somebody else, then you lose it. And that was never part of our agreement. But that was after recreational failed. So they didn't want to take the chance. I did the agreement as they asked, and I said, I want to be a good building owner. What's your concerns? We came to an agreement. And after recreational failed, they said, oh, out. The other thing they said was, we're not going to approve your security. We have the right to put the cameras anywhere we want. So if you put any cameras outside, I'm not going to do it because you have to get it through the CCNRs. I met, I don't know how many times with the police department to say, can I put the cameras inside? Went through every single camera, looked at everything, and they said, you're good, you're approved. Then got my certificate of occupancy. Otherwise, they would have blocked me for that as well. And that's what I feel like is going on right now. So,
Thank you.
Thank you so much.
You still do a call to the audience.
Yes, thank you. Good evening, ladies and gentlemen. My name is Edward O'Brien with the Travis Law Firm. My firm represents the Warner Village Office Condominium Association and its Board of Directors. The Board of Directors of the Condominium Association has approved this statement for me to read tonight with regard to the request for Park Dispensary to obtain zoning approval for a medical marijuana dispensary located at 8611 South Priest Drive. The unit is within the condominium association and is a member of the condominium association. It's the position of the association that such use of this unit for the sale of medical marijuana violates the recorded CCNRs, the Community Declaration, and is not a professional office use. This use restriction is set forth in Section 4.1 of the CCNRs. If a dispensary is to be considered for this location in Tempe, a medical marijuana dispensary would be better suited for a retail building, such as the ones on Priest and Warner on that same corner, as opposed to the office condominium buildings that are located behind these retail buildings. The city itself has distinguished between retail and professional office use twice during our discussion here tonight. The association and its members are concerned with regard to additional traffic that would be coming to and departing from the dispensary, the longer hours of operation of the dispensary in comparison to these other professional offices, which have a more standard Monday through Friday, 8 to 5 hour of operation, and what security plans proposed for the dispensary. The association is currently involved in Maricopa Superior Court lawsuit that is pending with the owner of this unit, Image Productions LLC, in regard to whether the unit can be utilized as a medical marijuana dispensary. The parties are awaiting a ruling from the Superior Court judge at this time, although we don't have a date of expected ruling. Given the association's concerns regarding whether such use complies with its condominium declaration, the nature of the business, which is retail, rather than professional office use, increased traffic, and longer hours of operation, it is the association's position that the Board of Adjustment deny Park Dispensary's appeal of the zoning administrator's decision. Thank you. If you have any questions, I'm happy to take them.
May I just say one quick thing, and I'm sorry?
No questions? Okay, thank you.
Yes. I'm sorry. Just a real quick point. They say it's office, it's medical. So it's office and medical and dental. There's a dentist in there, and it is approved for medical right in the CCNRs, and it's medical marijuana. Again, this is semantics, and this is, again, it's not reasonable. So I just wanted you to understand that.
There's no one else that wishes to speak, and there aren't any other. Do you have a question?
Well, I guess based on,
Mr. Frazee?
thank you. Based on that last two comments, so is the attorney for the association, is the comment that the CCNRs specifically prevent medical marijuana? I mean, is that the statement you're making?
Yes, the association has taken the position that a medical marijuana dispensary is not permitted pursuant to the CCNRs. That is at the heart of the case currently pending in Maricopa County Superior Court.
Thank you.
Okay, I don't see any other questions or comments. Okay, now I call for the question.
No right for us to discuss.
Yes, it'd be fine.
Okay, I'll. Thank you, Chairman Sell. I like the applicants, and I really like their candor and the honesty that they've given us tonight. Regrettably, that has nothing to do with how we make our decisions. I would say that I take issue with a number of the claims that have been put forth tonight. I don't want to, belabor things, but if anyone is interested, I'd be happy to enumerate. Gosh, there's so many things here. The distance, I find the appellant's description of distance to be in error. I do not believe that the use acceptance is transferable. It's not part of the property. It is not an entitlement of the property. It belongs to a business. I believe that Lifetime Fitness is a child care facility because they have a license as a child care license. They're licensed by the state. I could go on and on. I believe that the zoning administrator made the correct decision. I'd be happy to offer up opinions if anyone has issues with various things.
Any other discussion? I'll call for the question. Yes, Mr. Klein.
Chairman Sell, I propose that we deny the applicant's appeal, thereby upholding the zoning administrator's decision.
Thank you. Is there a second to that?
I second that.
Mr. Nodal seconds that motion. All those in favor, say aye.
Aye.
Aye. Opposed? Aye. Okay, we have two, so we have 1, 2, 3, 5 people that are for with dissension from Mr. Collison and Mr. Coswell. Therefore, the motion carries to deny the appeal and uphold the zoning administrator's decision. Thank you. And if there's no other business,
You
follow-up question to it. Is there any other business or
vote
question?
to adjourn?
Yes, I'm going to.
Okay.
Okay, so that's the motion to adjourn.
Chairman Sell, I move that we adjourn.
Mr. Lyon makes the motion. Anyone
Motion
else?
seconded?
Motion seconded by Mr. Coswell. All those in favor, say aye. Aye. Opposed? Thank you very much for your time this evening.